All right, well, we'll get started. Jillian Hatfield, who normally chairs these sessions, can't be with us today, so I will be moderating the talk for today. My name is Lisa Austin. I want to thank you all for joining all of us here. I'm a professor in the law faculty and a chair in law and technology, as well as an associate director at the Schwartz Reisman Institute. And it's my enormous pleasure to introduce our speaker today, Anna Sue, who is my wonderful colleague at the law faculty. She's an associate professor at the Faculty of Law here in Toronto with a cross appointment in the Department of History, and is also currently one of our SRI faculty fellows. Anna's primary areas of research include the law and history of international human rights law, US constitutional law, and law and religion. Anna holds an SJD from Harvard Law School, where her dissertation was awarded the John Leyland Prize for Best Paper in International Law. She received her JD and AB degrees from the Ateneo de Manila University in the Philippines. Prior to coming to Toronto, she held a postdoctoral fellowship at the Baldy Center for Law and Social Policy based in SUNY Buffalo Law School, and a graduate fellowship in ethics with the Edmund J. Safra Center for Ethics at Harvard University. She worked as a law clerk for the Philippine Supreme Court and was a consultant to the Philippine government negotiating panel with the Moro Islamic Liberation Front. And is also just a wonderful and fascinating person. We're grateful to have her with us today and thrilled that she's turning her prodigious talents towards the world of technology and digital constitutionalism. So Anna, I'm gonna pass it on to you, and we're all looking forward to your talk. Just one other preliminary matter, and it is indicated to me that she's open to having questions during the talk and not just once the talk is finished in a question period then. So if you have a question for her as she's speaking, either put something in the chat or put your hand up using the raise hand function, and I will monitor that for Anna. Okay, with no further ado, Anna.
Hi, everyone. Good afternoon. Thank you so much for having me here. I'm a bit of a latecomer to this area of law and technology. So I'm really happy to be part of the SRI, where I can get up to speed on this primarily by meeting all the great and interesting scholars from different fields. As Lisa mentioned, my background is somewhere in the intersection of international human rights law and constitutional law. So I wanted to bring that background to bear on this topic that I think is growing in importance. So this is just the very early stages of our project, and so what I really want to do today is just to make a survey of what is out there. What do people mean by digital constitutionalism? Why is it important to take a note of? What are the stakes in getting this right, for instance? And finally, in the end, if I still have some time, perhaps I'll just raise some questions that can be motivations for further reflections, such as to what extent has international human rights law has emerged as a global constitutional framework for these digital regulatory initiatives, and is it up to the task, and if there are any alternatives. So today, I mean, as this Zoom session can attest, if there's anything that the ongoing COVID-19 pandemic has illustrated, the world became even more dependent on digital technologies in many ways. So in the last decade, the rise of what is now being called the rise of the algorithmic society has led to a paradigmatic change where digital technologies have provided new opportunities for the exercise of fundamental rights and freedoms online, but it also raised concerns about the power exercised not only by the state, but most importantly by private technology companies. In this development, ever-present data collection, data mining, algorithmic analysis, they present unique challenges to our current constitutional arrangements and invite us to redraw traditional constitutional boundaries, legal categories, and revisit the relationship between public and private law. And by that, I mean the law between the people and the state, and between people and private corporations that often operate across many jurisdictions. In other words, the question is, do our current laws and regulations capture these relationships and ensure that our rights and activities online are protected in a similar manner, or even more so that they are in the offline world, and if so, how, right?
Anna,
And the
can I
answer
just
is,
can I just
yeah.
interrupt you just for a sec? I know you had some slides, and I just wanted to ask if you wanted to share your screen.
Oh, I
Just
was
in
gonna
case.
share it like
Oh,
after this part. Yeah.
okay. I just wanted to make sure. Sorry.
Yeah. No, it's fine. Sorry, I'm just giving like an overview, and then I'll give some of the definitions. So so as I was asking like what I was mentioning is that I guess the question here is that do our current laws and regulations capture these new relationships and ensure that our rights and activities online are protected in a similar manner, as protected in the same way that they are in the offline world? And the answer is mostly that they don't, right? Law is quite notorious for being unable to catch up with technology, sometimes for good reason, but in the cases that the law does address, it is often inadequate or inept. All right. So my current research, I'm going to show a bit of the. I have a few slides that I hope is sorry about this. I have a few slides that. So my current research focuses on what is now being called as digital constitutionalism, right? Which doesn't really have a precise definition at the moment. And among the scholars who've used the term, and I list them here, have described this as follows. So the earliest articulation of this term have been made by Urs Gasser, Lex Hill, and Dennis Rodecker, who described it as a constellation of initiatives that seeks to articulate a set of political rights, governance norms, and limitations on the exercise of power on the internet. Another one is by Nicholas Huzor, who defines it as a project to articulate a set of limits on private power with particular attention to virtual communities. A third one is Eduardo Celeste, who defined it as the ideology which aims to establish and ensure the existence of a normative framework for the protection of fundamental rights and balancing of powers in the digital environment. And then finally, you have the Gregorio here, who also defines digital constitutionalism as consisting of articulating the limits to the exercise of power in a network society. Now, they are cast in different terms, but the common denominator in all of these definitions is one of limitations. So let me backtrack a little bit and just give a very brief refresher about constitutions and constitutionalism, as I will be using these terms a lot in this talk. So a constitution in the old sense, for those people who are not familiar with this, refers to it refers to any document that purports to define and organize like a state, right? But instead to the manner in which a state is actually organized. So the very old conception of the term constitution in the Greek sense, Aristotelian sense of the term, is that what are the characteristics of a state, and therefore that is the constitution of a state. But we know constitutions today to be a bit different, right? Today, what we know as a constitution derives from the idea of modern written constitutions as a written legal text that establishes the government of a state and limits the exercise of its power. So here in Canada, we know that there is a written constitution. We have the Charter of Rights and Freedoms, which limits the exercise of government power. And this document derives its authority from the people and legitimacy from the people who are the sovereign, considered the sovereign, and the ultimate source of all state power. And so this is the basic idea of all the modern constitutions that are in use around the world. The other term, constitutionalism, on the other hand, is a bit more difficult to define, right? Generally, for those in liberal democracies, of which Canada is one, it just means that there are limits on the powers of government, and there is adherence to the rule of law, for example, and fundamental rights are protected. Now, a more descriptive and thin definition that could apply to countries, for example, with any system of government, not just a liberal democracy, is simply those ideas, theories, beliefs, and practices pursuant to which the country is governed, such that even non-liberal democracies also can have a kind of constitutionalism that is being practiced, right? So the title of this talk, I came up with the title of this talk a bit much earlier before I actually came up with a presentation. It's a bit misleading. The title of this talk is something along the lines of a constitution for the digital society, but this is a bit misleading because there can be no one single constitution in the digital society or in the metaverse of the future, but it is possible to have a very thin constitution in the sense that there is some type of rule of law involved, that there are sources of obligations, there are certain limitations, and there are mechanisms for review and accountability by the players involved. So I'll get back to that later, right? Going back to digital constitutionalism, the common denominator, as I've mentioned earlier, is the idea of limited powers and fundamental rights. And the scholars that I enumerated earlier, these scholars are borrowing these concepts from the mountains and mountains and mountains of literature on old school constitutional law and constitutionalism that has for its object the limitation of the power exercised by the state and then adapting them into the digital sphere. So if you look at the very rudimentary illustration that I have here, traditional constitutional law in theory is often concerned with the relations between state and the people, right? But today in the digital society, the state is as private tech corporations are as important as the state, arguably, in terms of the power that in the amount of power that they exercise, so that they should be the object of study and they should be the object of certain limitations vis-a-vis their relations with the people or the users of these technologies, right? So as we know all too well, there's more than just government and users in the digital space. And in fact, there's more than just one government, since the digital sphere knows no national boundaries. But the big tech companies and the platforms that they operate essentially govern the internet. And these are the private companies that create our software, develops tools and store our data, and the search engines that index that data, and the social media entities that connect us. This new configuration has created a complex ecosystem in which great power imbalances exist, often to the detriment of users who are subject to what I earlier described as ever-present data collection, mining, and analysis, often with little or no meaningful recourse or remedy. And so to illustrate, whereas in the offline world, you utter speech subject to existing laws and protected by the Constitution, at least usually, in the online world, your speech or whatever content that you might have is subject to a platform's terms and conditions, something that we used to associate with buying appliances. As Tarleton Gillespie wrote in 2017, digital platforms are architects of public spaces. And so if private companies are performing quasi-public functions and in creating and controlling these spaces, how do we want relationships in these spaces to be governed? So digital constitutionalism, this is the umbrella term for this project, is a response to the challenges and opportunities of this new landscape and takes various forms as countermeasures. And I'll enumerate some of these examples later. The idea here is that we cannot treat the digital space as unregulated as it was before. And the idea that technology has to be free from any regulation in order not to stifle innovation cannot be countenanced any longer. The digital space is too important to continue the way that it did. So on this note, it's important to think of this. I want just to pause here for a bit. I just want to emphasize the importance of thinking of this as a singular phenomenon rather than as disparate initiatives. Because as Gasser, like here, the definition that we have, this constellation of initiatives the term captures a common thread. So why do we call it digital constitutionalism? It captures a common thread that underlines in some important way the importance or the significance of protecting rights, establishing some governance norms, and limiting the exercise of power online. The digital constitutionalism, so that description there binds together the global internet, for example, and everything that it mediates with so-called big data analytics, cloud computing, Internet of Things, AI-based systems. So it's not just about the technical governance of certain parts, but governance of many wholes, right? And so we can think of digital constitutionalism as a meta legal system through which shared norms and rules as constitutional values with global implications may be produced and shaped. Now, there's a need certainly to ensure that multilateral normative frameworks across sectors, so data, content, physical network infrastructure, can promote equality and safeguard individual and collective rights. So why is this important? Like, first, I just wanted to mention this before I go to the examples. So why is this getting this right this time is important? So I have 3 reasons. From our internet circa 2022 today to a metaverse of some form in the not so distant future, I think it's important to set the tone, so to speak, in terms of the foundational intellectual blocks and get this right for 3 main reasons. The first one, as you see here, is path dependence. A constitutional perspective is important because it's crucial to create the kind of online future that protects equality and democracy. And here I want to offer the cautionary tale of the deregulatory origins of the internet. There's as Elettra Biletti, who's a very prolific emerging scholar, she has this piece called A Genealogy of Digital Platform Regulation. Her question is, how did we get to our present predicament of an internet filled with private enclosures ruled by a few who leverage access to data, attention, and infrastructural capability to enclose users and competitors in relations of dependency, right? Another work that deals with the origins of digital platform regulation is Giovanni de Gregorio with respect to content and data regulation in the European Union. So in both of these works, the Gregorio in particular traces the origins of the EU doubling down on efforts to make online intermediaries more responsible for the content that they host, as well as the steps that they take into account in order to protect rights and freedoms of their users. So in both of these works, they have a similar story. The internet was deemed to be an autonomous space separate from the nation state, right? So John Perry Barlow's Declaration of Independence in Cyberspace in 1996 was paradigmatic of the libertarian thinking of this period. So this was a very optimistic view. The idea is that the state or government should not involve itself with the internet because it would end up hindering creativity, open access, and development. And Biletti suggests that this illusion was grounded in a belief that questions of legitimacy, sovereignty, and power online could be treated as distinct from questions of legitimacy, democratic governance, or power offline, right? And there's more to this origin story, of course, and I think that should be the subject of a different talk. But I think the important point to take away from these 2 scholars' work is that they tell a story of path dependence. Our internet today is controlled by centralized intermediaries that thrive upon surveillance capitalism, thanks in part to past trends and visions of what the law, freedom, and power should be, right? And so new visions of how to construct our online future, of which digital constitutionalism should be a part, must be aware and critical of these past errors and conscious of its limits. The other reason for why thinking about digital constitutionalism is important is that, at least for constitutional lawyers like me, it's important it's an opportunity to redeem liberal constitutionalism. Our digital reality has made manifest the shortcomings of our current understanding of law and how it is inadequate in addressing our pressing needs. So digital technologies, as we know, not only affect individual lives, but shape our collective social systems. So digital constitutionalism here is not simply coming up with more regulations, but it's also coming up with new questions. Right? One frequent example here is the critique that rights, for example, or the rights framework is inappropriate for thinking about, for example, AI-based systems, right? Because it's often difficult or implausible to isolate a pair of actors. So you have, usually you have two parties, the offender and the claimant, for distinctive treatment, especially when it will be enforced by a court of law. But rights frameworks, as I will defend them, has already the advantage of being widely accepted, and it can also be flexible enough to be interpreted in a non-individualistic or a structural way. Another example, of course, is the failure of old school liberal constitutionalism to address issues of distributive justice, given its overemphasis on civil and political rights. And so digital constitutionalism, the opening up of the digital space, offers an opportunity to revise or to change our prevailing understanding of rights in a way that captures the reality of the online world. So for example, how does the reality of the gig economy, for instance, influence or change how we understand the right to work? And finally, the third reason for understanding digital constitutionalism right is that it would allow us to allow a more inclusive and global kind of democratic governance for our interdependent online reality. The exponential growth of technical and regulatory issues associated with the internet, thanks to advances in data, AI, blockchain, Internet of Things technologies, I think has broadened and deepened the technological and the governance gap, and has led to the increase of voluntary and private rulemaking initiatives, of which, for example, the Facebook Oversight Board is the most prominent one. But I think a lot of these voluntary and private rulemaking initiatives is often considered to be an escape route for evading human rights-based or more binding public regulation. Moreover, our digital future is also subject to geopolitical competition between China on the one hand and US/Europe on the other. And so in the so-called race to regulate AI, which is different from the race to develop AI, because Europe now has the most robust, I would say, regulatory setup for new technologies at the moment, and it is its explicit intention to have that so-called Brussels effect when it promulgates, for example, the AI Act as a template for global AI regulation. The question here is, then is this actually going to be helpful for everyone? So if all the rules, for instance, come from the West without any input or participation from people beyond Europe and North America, even though most of them will be subject to these rules, then it will inevitably have those structural biases built in these rules. And so what we need here, what this project is trying to advance, is a conscious, concerted attempt from all the stakeholders, governments, not just from the West, international organizations, civil society groups, to flesh out what are these meta-legal norms, rules and principles that we aspire to apply to the online world from now going forward. So here, I picked up this visualization of all the internet bills of rights. I'm not gonna list whatever is in them, but one of the things that I want to say is that this idea of digital constitutionalism is not really that new, right? Proposals for an internet bill of rights, for example, has been around in the early or mid 2000s. And as recently as 2016, for example, the UN Human Rights Council adopted a resolution that affirmed that people's rights offline must also be protected online. And like other UN documents, This suggests that the internet is a fundamental enabler of human rights and implies that the current understanding of human rights as laid out in the Human Rights Declaration can be applied to the internet. So I just want to run through some of the initiatives that are engaged in by different actors. These examples are by no means exhaustive. I just want to give you a flavor of what's going on out there. This visualization that we have here is was done by some data visualization group on an article by Urs Gasser, Lex Hill, and Dennis Redeker on what are these internet bills of rights that are going on at the moment in 2018. So this is not up to date, but you can already see that there is a lot of attention being paid towards these kinds of initiatives. And so I'm just going to go through some of the more recent ones. So some examples at the governmental level, you can see here, for example, that Spain recently enacted a Charter of Digital Rights as of July 14, 2021. Some of the rights encapsulated in this or included in this charter include the right to data protection, right to pseudonymization, right of the person not to be located and profiled, right to cybersecurity, and right to digital heritage. Another one that is also 2021 is in Portugal. They also have a Charter of Human Rights in the digital era. They have all of these like very interesting rights, right to be forgotten, right to protection against abusive geolocation, right to assembly in a digital environment. One interesting thing that is also included in this charter is the obligation of a state to foster the creation of a social tariff for internet access for economically vulnerable users, right? The other examples here that I have are Brazil and Italy. So Brazil is the very first country to have a kind of an internet bill of, like a binding internet bill of rights. It was enacted in 2014. Italy has a Declaration of Internet of Rights also in 2014. And then I included here the US because this was the proposed Algorithmic Accountability Act, for example, was first proposed in 2019 and then reintroduced in 2022, just last month. It requires companies to conduct impact assessments for algorithmic decision-making systems with description of privacy risks. So there's a lot of activity. I just want to point out, so you can see that, for instance, the rights that are being included in these digital rights charters circa 2021, 2020s include these, what I would call new rights, like for instance, right to be forgotten, whereas you wouldn't necessarily find that in the 2014 internet rights proposal. A lot of them are simply reinterpretation or extension of existing rights and then making them apply to the digital environment, and which I will get to in a moment. Some examples by private companies and other private organizations, as well as non-state actors. So by non-state actors, I just look at, for example, this Toronto Declaration for the Right to Equality in Machine Learning. This was issued in 2018. It was signed and endorsed by a lot of civil society groups that are concerned with human rights and AI. I also included under the non-state actor category the decisions of the Icann, which is the main internet the main internet body that deals with domain names. So the dispute resolution mechanism of the Icann often incorporates international human rights case law on freedom of expression, and their case law arguably, at least in my view and a few other scholars, can be argued as a source of norms, at least with respect to freedom of expression for other kinds of digital contexts. Another category here is efforts by private companies. So self-regulation efforts by private technology companies, unsurprisingly, take the form of some kind of soft law. Soft law meaning they're not binding. It's either a self-adopted code of conduct, these are best practices, these are ethics guidelines, or some other kind of voluntary initiative. In the field of content moderation, as I mentioned, the Facebook Oversight Board is the most prominent because it has been touted as the Supreme Court of Facebook. In Google also has, at least in Europe, also adjudicates disputes with respect to the right to be forgotten. But again, it's that's only within the that has geographic limitations. Once upon a time, part of this effort to also come up with some kind of balancing or limitation on its powers is Facebook announced in 2009 and up to 2012 there was this experiment by Facebook to incorporate democracy into its policies. I don't know if anybody remembers this, but Facebook announced that it was giving its users the opportunity to vote on the terms that they preferred, and so it was a modest step towards acknowledging that that this new technology deeply affect our lives and in ways that's not always captured by the typical relationship between consumer and seller, right? And so Facebook came up with something called the Statement on Revised Rights and Responsibilities, but that has since been that's now obsolete, as we know. So but the fact, what I'm trying to say here is the fact that these are voluntary initiatives, as I mentioned, should not detract from their value as contributing to the current digital constitutional moment, right? So I mentioned earlier that sometimes companies adopt these kinds of regulations because they want to evade binding regulation. And so, but these are also helpful. These attempts at self-limitations are also helpful because they can be the evidence of an emerging norm. So sometimes companies adopt these because they can foresee some kind of regulation coming up there or approaching their way, and so they want to be able to prevent that from happening. But these guidelines can also be points of cooperation between the private company and traditional public authorities or the government that can later harden or get formalized into a rule or legislation. So for instance, tech companies such as Google, Microsoft, AI have all announced ethical AI principles and statements that will guide them in their product development. And so these private standards can be used should they fail to adhere to these standards, right? Another one here is at the international and supranational or regional level, you have, again, you have a bunch of these declarations on internet rights and freedom. So there's an African Declaration on Internet Rights and Freedoms. You have this Charter Internet Rights and Principles Coalition, where they have the Charter of Human Rights and Principles for the Internet. And the European Union, as I mentioned at the beginning, has the most robust regulatory setup at the moment. They have the General Data Protection Regulation, which introduced new data subject rights. There are these proposed acts. So the Artificial Intelligence Act and the Digital Services Act are not yet binding, but they're in the process of they are getting to the point where they are going to be enacted as hard EU legislation. So Artificial Intelligence Act is aimed at introducing a common regulatory and legal framework for AI. They include different rights, including a right to know if and when people are interacting with a machine's algorithm, right? And they have a human oversight requirements for high-risk AI systems. The interesting thing about the Artificial Intelligence Act, it adopts the same risk-based system as in the GDPR, is that it divides. I mean, it's a culmination of many years of discussions. There's a risk-based regulation system that will be put in place. There is an unacceptable risk AI system. So this has to do with behavioral manipulation of persons or specific vulnerable groups, social scoring, remote biometric identification systems. But then you have these high-risk systems for which human oversight is required. And you have these issuing of credit scores for loan purposes, migration or border control management, surveillance systems. So in the Digital Services Act, again, this is another one that is pending promulgation. It's meant to update the e-commerce directive, and the goal is to create a safer digital space in which the fundamental rights of users of digital services are protected. So some of the new rights that they've come up with under this act is the right to use and pay for digital services anonymously. The other thing that's new with this act is that it obliges the platforms to take a more systemic view of the risks that they're introducing in the operation of their platform. So, for example, there is a prohibition from using or nudging techniques to influence users' behaviors. There's a refusal. Users can refuse consent to be tracked, or at least make it more difficult in refusing to be tracked, for example. So these are some of the major pieces of regulation that's coming out of the EU. And again, as I mentioned at the beginning, the EU has there is an explicit intention on the part of the EU to have that so-called Brussels effect and have these new rules be a kind of a global template for global AI regulation. And while these are certainly very protective of the rights and freedoms for people within Europe, I think it remains to be seen what are the implications or the consequences for people outside of Europe who are be subject to these rules in any case. The other one the other effort, another piece of this of digital constitutionalism is the creation of new rights, right? Here I have this screenshot of this very helpful and excellent article by Daphne Dorsch-Polyansky and Yuval Shany. It was just published last year, and it talks about efforts about creating new what we now are calling as digital human rights. So why do we need to add new rights? Like, don't we have many as it is already? And the justification for this, as Polyansky and Shany argues here, is that a tailored vocabulary, one that takes into account the very unique and distinctive characteristics of the online space, could convey a much clearer standard of conduct and increase the legitimacy of claims by stakeholders. So I already made the, I showed this example, for example, I showed this example of the Charter of Human Rights and Principles for the Internet, right? The Charter has a list of rights and principles which aims to provide a framework for upholding and advancing human rights for the online environment. But it's not, it does not, so that's just one initiative. In this article, this on the digital human rights, they argue that there are limits to how we can interpret existing rights. There are certain activities that cannot be captured by the rights that we have at the moment, right? So they call this the second generation rights. And they argue that this is necessary to protect the unique online needs and interests that are not fully or effectively covered by the application of traditional human rights to cyberspace. So first generation rights, just to repeat, refers to the existing ones and the ones being reinterpreted for the digital space accordingly. So for example, you have freedom of speech offline and you have freedom of speech online, right? But there are certain things that, again, you don't have an equivalent. And so Shany and Polyansky argued that the emergence of a new vocabulary of digital human rights norms could encourage online users to develop a sense of entitlement for enjoying online rights and facilitate over time the creation of suitable and effective remedies for violations that will occur. And so this is one of the most recent attempts to argue for these new distinctive rights. Um, Although, as I mentioned, a number of internet bills of rights have been are being proposed and suggested since the early 2010s, there are new rights that are being articulated in the last 2 to 3 years that have taken into account advances in data collection and proliferation of AI-based systems, especially in the realm of law enforcement and judging. There's tons of literature now on how such practices endanger individual freedom and impair human dignity. And as we move on to the adoption of Web3 and other attempts to decentralize the internet as we know it today, thinking about these new rights and how we can elaborate on them is more important than ever, as there's a lot of legal, moral, and social justification involved in creating and recognizing new rights. So I just want to briefly run through some of these so-called generation rights and see perhaps like some of them might pique your interest. So the first one is right to internet access. This has been suggested and promoted at the UN level as early as 2011, when the UN Special Rapporteur for Freedom of Expression issued a report focusing on this right. Since then, it has really spawned debate. In fact, there's a debate between Tim Berners-Lee and Vint Cerf, both pioneers of the early internet. Vint Cerf asserted that internet cannot be regarded as a right because it's simply an enabler of human rights, right? So when we talk about human rights, the argument goes that it has to be among the things that humans need in order to lead healthy and meaningful lives. And so he thinks that the internet is not really one of them, because while you need the internet, it's not really, in order to enjoy those rights, it's not really the internet per se that you need. But I just wonder if that view, and this debate was in 2014, I wonder if that view still holds today, because we have, for example, the rise of what is now called as the digital welfare state. And that means the delivery of social protection assistance systems in digital form. So identity verification, risk scoring, welfare benefit calculation and payments. People who do not have access to the internet do not have access to all of these, and therefore it can impede the ability of people to realize their human rights. So it's not just a matter of like, it's not simply a means, it might actually be where they realize their human rights. So there's a lot to that. That's one of the more debated and discussed so-called new rights. The other one's the right to network self-determination and network neutrality. You have a digital Geneva Convention that was proposed by Brad Smith at a General Counsel of Microsoft in 2017. And this has been endorsed by the UN High Commissioner for Refugees, and which acknowledges essentially that private technology companies have a major role in defining matters of human rights and humanitarian protection in digital space. So the Digital Geneva Convention has to do with protection of civilians in the event of a cybersecurity, in the event of a cyber attack. The other one here that also has been the subject of a lot of academic debate and discussion is the right to be forgotten. Again, it's the right to have private information about a person be removed from internet searches. So the EU, Argentina, and the Philippines have this. It first appeared in 2014 and is now one of the more popular rights. Another one the two more related rights here is that you have right not to be subjected to an automated decision maker and the right to contest automated decisions. So the right not to be subjected to an automated decision is, according to George Polyansky and Shani, is one of those that have no equivalent parent right in the human rights that exist today. And to be subject to an automated decision is to entail a certain dehumanization, since human beings are simply treated as data sets. So that's one of the justification for advancing this right as in order to get some kind of recognition that this should be a right that we have. Related to this is the right to contest automated decisions, which is also related with the right to an explanation, right? And then finally, I just wanted to include this. This is one of the very most recent one that's been proposed by philosopher Matthias Reis at the Harvard Kennedy School, the right to exercise genuinely human intelligence. And Reis describes this right as a fourth generation human right that is concerned with humanity's relationship with entities of similar or larger intelligence that would eventually share our life worlds. Right. So what are these? So these are just some examples. What I'm seeing here is that the convergence in the academic discourse, policymaking circles, non-binding resolutions at the international level, and various reports reflect at the very least a consensus that in view of our digital reality today, we need to develop new rights, especially perhaps the right to the access to the internet. Now, there's a lot of critical writings on the idea of creating new rights, and the most prominent of which is that if everything is a right, then nothing is. And I don't want to get much into that, and I think that it remains to be seen how those views have changed given our situation at the moment. Just one more. Now, how do we all put this together, right? What we have right now is a new wave of soft law, meaning the codes of conduct, guidelines, principles, and hard law instruments, meaning hard law, there is a binding effect aimed to regulate online intermediary activities in the field of content and data by introducing new obligations and rights. So it's not just a top-down process, but a bottom-up one. So a lot of the demand in the discourse is being driven at the societal level, right? And so I think it's helpful to point out that one of the goals of digital constitutionalism is to legalize these norms into binding legal documents. But at the same time, we do not need to wait until these norms become enacted law before they act as some kind of normative counter to the exercise of power, especially by private entities. So how does this work? As a constitutional lawyer, first and foremost, I'm very fascinated with the evolving constitutionalization of the digital space, the expansion of the constitutional lens to go beyond the state and one that includes powerful commercial actors as the main holders of power, and the attempts at translation and innovation of constitutional concepts and theory. So do we adapt and reinterpret these 18th century ideas, or do we come up with entirely new ones? So this is where I would probably place my own intervention in this field. And certainly there's a lot of work to be done in this area, which is really just emergent and is quite reflective of our particular historical moment. And for technologists, I think one of the most challenging and important dimensions of this development has to be how to incorporate human rights values and bake them into these technologies. What does privacy by design mean, for example, or how do we design systems that preserve human dignity? So I just want to include this illustration to say, like, how do these norms and values work? So for people who prefer to look to visualize things, this which is basically me as well. So all these constitutional norms and values that are produced by a variety of sources. You have constitutions, court decisions, statutes. You have codes of conduct by private corporations. All of them get enforced and they get permeate, infused all the attempts. Like I'm using the layers of the internet by Yochai Benkler. So you have the content layer, the logical and the physical layers. And for example, in the content layer is where you find data, you have online platforms, social media, you have all of these norms and values bearing on the development and the operation of those platforms, right? Okay, one last thing. I know I'm running out of time, but one last thing that I should point out, that there's a lot of human rights talk that I just made in this presentation. And I already mentioned this critique earlier when I said that one of the things that, at least in law, a lot of scholars always suggest that maybe rights is not always the most appropriate tool that we have in order to, as we think about safeguarding our interests, such as equality, autonomy, and dignity when it comes to AI-based systems, because the situation is often more complex than just being boiled down to a dispute between two parties, right? So what is the alternative then? I don't have any answers, but I do think that that critique is fair and valid. Even the most robust rights regime, I don't want to give false hopes to anyone. Like the proliferation of these rights to give you a sense that, oh, maybe things will be okay. But even the most robust rights regime has limitations in an overall political economy in which the business model of most, if not all, tech companies is one of surveillance capitalism, which is around the commodification of personal data. And so to address that much bigger problem requires a related but slightly different conversation using other tools, but one that should be very much a part of the digital constitutionalist toolkit going forward. And perhaps that is one solution that requires thinking and creativity, and not just from lawyers, but from people from different fields. And so I'll just stop with that. And I hope I piqued your interest enough to looking forward for your questions.
Thank you so much, Anna. That was terrific. So the floor is open to questions. If you just use the raise hand function, or if you want to put something in the chat, I can recognize you there as well.
It's also okay if you don't have questions. That's a lot of information.
Well, as the other lawyer here, and we have some law students as well, there's lots of legal questions, but I don't want to get down into the sort of nitty gritty. I'll let other people ask.
Yeah. We have this in person, we could be eating now.
All right, well, I'll exercise my prerogative as chair of the session. And I had a question for you. Your last comment in particular really intrigues me, because I think there's a lot of interesting questions about how we assess kind of the systemic effects of technology on rights in different ways, and how do we get at some of those aspects, and especially if you want to dig down into sort of the other layers of sort of the digital realm as well, and not just content, but how we build things and whatnot. So there's this idea, I don't know if you've come across it in the sort of digital constitutionalism kind of stuff that you're reading about, but in some of the more privacy literature and science and technology studies literature, scholars talk about affordances sometimes. And I know Dennis is on the call here, and he uses it in a certain way in his world as well. But in kind of the space that I'm thinking about, the idea of affordances would be like, technology is created in such a way that, makes some things more likely and other things less likely. So it's not that a technology itself would necessarily violate a right in that kind of classic rights framework, but it makes a certain kind of future more likely, and a certain other kind of future less likely, and that future that it's making that's more likely has implications for rights. It's just not in that kind of rights violation sort of framing. And I'm just curious, I don't know if that's been part of that digital constitutionalism discussion, but I'm curious as to whether that sort of idea resonates with you in terms of how we think about some of those more kind of systemic questions.
Right. No, that is definitely one of the, I guess one of the more pressing questions, right? Like, I think by now everyone recognizes, or at least a lot of people now recognize, that this is not just about individual remedies, but something about collective or societal risks that we're talking about. And I think the language in the EU Services Act, so two things. One is there has been, I read this piece about that certain technologies should not, like the idea that we should even entertain the idea of not developing certain technologies. That's the first thing that came to mind when you mentioned something about, certain technologies make some things, scenarios more likely rather than less likely. And so if we come up with an agreement, for example, that there are certain technologies that will not be used, or we will ban facial recognition in certain contexts, for example, right? And so that already goes a long way towards creating that kind of reality, or that kind of future in which people are not going to be subject to some kind of ubiquitous surveillance outside of certain contexts, right? The other thing is that I think in certain, I mean, more people are thinking about these things in the context of online platforms. So, and social media in particular, I think that's the one area that has really been studied a lot by scholars lately. And one of the features of this Digital Services Act in the EU is that this risk-based classification is that there's a concept of systemic risk that's baked into the legislation. And basically, it obliges the platform into thinking, into assessing its own technology and incorporating that idea. Of course, nobody knows what systemic risk means, or at least there has not been a lot of discussion yet. But what the systemic risk means in if you put that in a piece of legislation, and if you're the social media company, what are the metrics by which you would assess that your technology poses a high or moderate or low level of systemic risk, right? But I think now people are starting to adopt certain language and starting to incorporate it in certain rules and regulations in recognition of the fact that it's not just about giving individuals certain remedies, but something that we have to look out for the collective welfare. So yeah, I think it is an interesting project, and it's very much context dependent. And a lot of the action is happening in Europe, and so I think we'll see a lot more coming from there in the next few months at least.
Thanks. Shashank, you're on my list next.
Yeah, so I work on blockchain and decentralized autonomous organizations. And the way I'm looking at it is like it's only the systems which are being online have to take care of them because of like different legislations in different countries. And the systems right now are moving away from platforms to protocols in the Web3 decentralized worlds. And over there, people are able to express their opinions, look at the code, which is mostly open source. And like there's a lot of transparency which is coming along in these kind of systems compared to the traditional big tech companies or how the tech is working currently. Do you see that like decentralization and collective decision making online could be fixing some of the issues, and that would be the next logical step to digital constitutionalism?
Oh, thank you so much, Sasha. From what sorry, can you repeat the first part of your question? Just the first part.
Like in short, maybe I'm just looking at the like the progression towards Web3 as a solution to like higher involvement from the society, and also something which is like more collective decision making and consensus at the level of rights and freedom.
Right. So yes, I mean a lot of the discussion and debate on this so-called digital constitutionalism is actually coming from civil society organizations, right? Because I think this is important because civil society organizations are for the most part they're transnational. They involve actors from different countries, and so they take into account that the reality of Europe or US or Canada, for example, might be different from the situation if you're in Asia. And so like people in these civil society organizations that are geared or focused on like protecting certain rights and freedoms online. So again, it depends on the context. So that their focus can be privacy, for example, or their focus can be freedom of expression on social media. And so it's important that this movement is coming from below, because I think it has more chances of well, first of all, like it's the bottom up, so to speak, process of norm creation, like creating these values, norms, this idea of like, oh, we want the right to be forgotten, for example. Like if this is something that came only from the government, for example, or like from some expert group, it's not gonna get as much buy-in as much legitimacy as it does when it comes from multi-stakeholder organizations or multi-stakeholder coalitions, meaning there are people who are not just from civil society, you have people from academia, you have people from consumer advocacy groups, those kinds of things. So yeah, I mean, a lot of these seemingly voluntary online groups, online decision-making systems, once they come up with something, and you can see that there's a trend that usually happens. What happens in Asia can also have a similar effect in Canada, for instance. Then you can see that norm emerging and crystallizing into something more normative, so that it doesn't have to be a law, but once it has enough support, right, from different sectors, you can see that that it will spur the private companies into changing their behavior, or at least that's at least one optimistic view of regulation.
And also a quick follow-up question.
Yeah.
What do you think about the decentralized autonomous organizations?
I'm sorry, decentralized.
Autonomous organizations.
Oh,
The
by
DAO.
like if you mean by decentralized autonomous, oh, I'm not very familiar with that. Are you referring to just like regular non-profit organizations?
No, there are a lot of organizations which are spawning up in the Web3 space, in the blockchain and crypto space.
Right. Oh, okay. I get it. The decentralized apps and all that. Yes. So I haven't seen a lot of literature on activism and grassroots advocacy with respect to Web3. And so, I mean, that might be a good space, uncharted space to look into. So thank you for that idea. But yeah, there's a lot of activity going on there from the companies, but I'm not aware of so much from like traditional civil society organizations that are advocating for certain rights in the Web3 community.
Right. Thank you.
But yeah, no, that's a great idea. Thank you.
So Anna, we have a question in the chat from Marion who asks, are you able to tell us more about a right to exercise a genuinely human decision? What does that mean? And thanks for a very interesting talk.
Yeah, this is a very thank you for this. This is a very interesting paper. I mean, I'm just looking at all these new rights literature recently in the past few months, and this is one of the more recent ones by Matthias Reis. It's a philosophy, like Professor Reis basically. I think this right to exercise a genuinely human decision has to be looked at in the context of we are human beings and there will be entities. So I guess artificially intelligent entities that will have some kind of consciousness that will eventually, share the world with us. And they would have some, again, the concern here is how do you preserve human dignity, right? And I think what he's trying to say in that paper, I mean, I have yet to really, I mean, I looked at it, but I haven't really engaged with its philosophical arguments. But the idea is that there should be, he's proposing that, in the context of having all these other possibly more intelligent conscious entities with us, there has to be a way to distinguish humans from them. And we want to be able to make this kind of decision. So the genuinely human decision here refers to an actual human being as opposed to like an artificially intelligent one. But I'll send you the paper if you can.
That would be, or even just, yeah, that'd be great. I'm very interested in that. Thank you very much. This was really interesting.
Okay, great. Matthew.
Great, thank you so much, Anna, for your talk. Can you all hear me, by the way? Sorry.
Hi, yes.
Okay, sorry. Yeah, I apologize. I'm having some issues with my tech, so I can't appear on camera. Anyway, thank you very much for the talk. I had a question about sort of the individual nature of rights versus maybe a collective approach to constitutionalization. So there's a lot of talk in the sort of content moderation space in which I work about whether or not the approach to a lot of these issues should be focusing on having individual rights for people as sort of a constitutionalization, or whether this should be treated as a collective way. We should be looking at private companies, their private power as something that's to be regulated more sort of through probabilistic, maybe that's not the right way of putting it, but we should be treating them as sort of, the scale of these things is so big that we can't focus on individual rights. We need to focus on ensuring that they have risk assessments, that they do their own sort of internal auditing, rather than giving individual rights to people to bring them to those companies to get hearings, those types of things. And I'm wondering if you had sort of thoughts on that, if we should be focused on an individual rights modality, or if we should be focused on sort of a from above administration focused way of dealing with private power.
Right. Thanks so much for that question. No, that's a great point. There is this debate. I think a lot of it has to do with a lot of this debate has to do with how we just traditionally understood rights. I don't think rights is necessarily, I mean, it's necessarily individualistic in how we understood it for time immemorial, but I don't think it's impossible to understand or conceptualize rights in a more collective or in a more structural way. So there is this work by Barry Sander on content moderation, in fact, and how the European Court of Human Rights, for example, has interpreted certain rights. So it's not basically the demonstration is that it's not impossible to think of rights in a way that goes beyond the individual. So it might be the case that you have individual claimants or individual complainants, right? But when adjudicating these kinds of disputes, I mean, ex post, of course, ex ante, you can impose, as you said, like risk assessments, certain kinds of obligations on the platforms that ensure that they safeguard the rights of everyone. There's more collective and structural way of thinking about it, but ex post, when you adjudicate these kinds of disputes, it's not impossible to understand rights in a way that reinforces its more structural aspects. So again, there's a lot more literature on this with the European Court of Human Rights in the European Court of Justice. And they managed to do that in certain when it comes to free speech and freedom of expression cases. But I think it's just that we're so conditioned with this idea of what Barry Sander called as marketized conception of rights, meaning it's all about the individual without regard for the overall the political economy in which that individual or the company is embedded. But it's possible to do that. It's just that I think courts are just conditioned to do otherwise, and that's why I felt that digital constitutionalism is important, because I think we're still at the very early stages of regulating tech companies and technology in general, and so I think this represents a great opportunity for us to change our conception of our rights in this space, right? So to be more flexible about how we understand these things in the digital space, at least.
Great,
I'll send you the article if you haven't come across that. And
sure, yeah, that'd be helpful. Thank you.
Great, Brian.
Yeah, thanks very much. A very interesting subject matter for sure. And I have a very inchoate question. So I'm struck by a kind of tension, it seems to me, between two things. And I should say right off that I'm not part of these discussions, and I'm not a law person myself at all. But it seems to me that with respect to, spam and trolling and a whole lot of things, there's the internet is such that people are able to act without taking responsibility in a certain kind of way, and the anonymity and so on and so forth allows hiding. And if you're bringing a kid up, one of the things you do is you say, look, you smashed the window of the guy next door, and we're going to go over there and we're going to tell him we broke his window and all kind of stuff. There's this sort of standing up and taking responsibility for your actions and so on and so forth. On the other hand, a lot of these rights, there's rights to anonymity,
right,
and so on and so forth, which seem to me to be sort of embodying rights to not take responsibility in a certain sense. And I guess what I'm concerned about is, where is the conversation? This is more ethics than rights, but where is the conversation going to happen about what constitutes the ethics of being human in an internet connected world? It doesn't seem to me that digital constitutionalism, I mean, you're sort of accepting it seems to me, that, I mean, correct me if I'm wrong, but it's sort of like accepting a sense of the human condition, which might not be too inspiring. But how are we going to bring kids up to sort of understand what it is to be a good human being in the internet enabled world? What's the locus of that discussion? Do you have any sense?
Right. No, that's a great point. I always like in constitutional law, there's this term called marketplace of ideas, and one of the justification for freedom of speech is the search for truth. And when students say this, I always tell them, have you seen a YouTube comment section? And of course, you see all sorts of things there. I get your point. I mean, this whole right of, I mean, there are also other justifications why we want to protect the right to the right of anonymity. We don't want to be known in a certain, for security reasons, for example. That's why there's this whole debate about Facebook requiring a real name, for instance, as opposed to Twitter, for instance, where you can have an anonymous profile. But I forgot to mention this in my talk, but one of the things that I thought that, again, why I think this digital constitution offers an opportunity to revise our understanding of rights is that we can reintroduce this lost idea of duties and responsibilities that come with rights. Right. There used to be, in the human rights literature, for instance, there was this idea that rights and duties used to go together, and somehow they fell into obscurity in the 1970s. And so now we have a very neoliberal conception of rights in the sense that it's all me. And without any concern for, the overarching sense of duty and responsibility. And I think, you're right that this is the best opportunity to introduce that concept, reintroduce that concept, because this is not something this is not new, right? There's in many cases, especially outside of the West, for instance, it's not just about rights. There's the emphasis on the idea of duty and obligations or responsibilities is very much alive alongside the idea of rights. And so I think, again, this is an opportunity to reintroduce that notion. And also that's why I wanted to mention that Facebook experiment at democracy in 2009, 2012, because they did have that statement on revised rights and responsibilities for users, right? So it's not just about the rights of users, it's also about the responsibility. And so there are a lot of these things that we can excavate from the past that, we can like reintroduce, and hopefully this will make for a safer online future.
Well, and also if I could say the whole idea of privacy troubles me actually, because the idea that this is my information and so on and so forth, it's a very capitalist ownership idea. I don't know that I agree that information about me is mine. It seems to me really quite a problematic idea, and yet it's sort of seems baked into this idea of privacy. So yeah, if you could do this excavation work, that would be great.
Thank you.
We have other questions, because I know I have lots, but I don't want to jump in and monopolize Anna's time. Okay, well then I will ask one question, Anna, because I know you think a lot about also the boundary between constitutionalism, so by which I just mean sort of like national constitutionalism. So for example, like, the Canadian Charter of Rights, and then international human rights, so a more international context, and the relationship between those, and now adding sort of private sector, right, tech companies into that who operate globally but also nationally. So I'm just kind of curious as to how some of those dynamics might play out in this space. So here's an example. I don't know if you have thoughts on but that troubles me in certain ways, although it doesn't trouble a lot of my colleagues in the privacy community. So here's my privacy skepticism, Brian, that maybe you'll like. So the example is around the COVID apps that came out, like the exposure notification apps. And set aside that, they weren't, in the end of the day, particularly useful in places like Canada. But there was a lot of questions about how they should be designed, and there was a lot of convergence on a certain design that we'll just say it was considered privacy first. Okay, and this was this decentralized Bluetooth technology that some people on the screen here know about, but it doesn't really matter for the example. So there's convergence on this sort of privacy first design, and it was really a design that needed the certain enabling activities from Google and Apple to make it work. So they had to do some stuff, let's just say. And so if you wanted to create an app that actually worked properly, you needed to do what Google and Apple said. And what they said was use this privacy first version. So it looks like a win for privacy. It's certainly consistent with international human rights norms. It's certainly something that plays into the sort of global space. Like if you're worried about authoritarian countries, then you want this kind of privacy first kind of version of the app. The disquiet that I have about that then is the intersection with kind of national constitutionalism, because there's nothing about the charter and how the charter protects privacy that says you needed this absolute privacy first version. You could have had, mostly privacy with a little bit of, additional kind of, information collected that would have allowed it to be integrated into, say, the human contact tracing system. You could have met public health goals more easily by collecting more information in a way that would have been completely consistent with our Canadian constitutionalism. But you couldn't do that and do it the way that was going to be enabled by the tech companies, because they were like, nope, can't do that. If you do that, you're on your own, and then it's not going to work properly. So what you had was private sector actors looking like they were actually being very responsible in terms of being norm responsive, certainly consistent in a certain way with international human rights norms. But we could have done that still. You could have had a different design that still would have been consistent, or at least with, for sure, I'm much more confident saying it's consistent with Canadian constitutional norms. But our democratic government cannot choose to do something consistent with our constitutional norms because the tech companies have said no. And that seems to me really problematic and introduces other power asymmetries that are troubling. I don't know how you get around that. I mean, I'm just sort of it's a naughty kind of conundrum. So I was curious as to how your way of thinking about international rights and constitutional, because you know more about kind of that general space than me, kind of might sort of pick your way through that.
Right. No, that is like, in a way, that is like the core question of digital constitutionalism, right? Like, how do private companies have this much power? I mean, obviously, they can always justify that, oh, but this satisfies human rights norm, this satisfies, this is very much rights protective, but at the same time, who's making that decision, right? And I think with respect to the digital space, and I think that's probably why I also think that this merits a different field. This whole digital you cannot just adapt like traditional constitutional law to this space, is that the private companies are as powerful, or even more so in many ways. I mean, if you look at the private companies, tech companies, like shutting off platforms in Russia at the moment, for example, like, they have that kind of power, like that they can use either for good or ill, right? But the question is, like, why do they have that power in the first place? And I think that's, I mean, if there's anyone, who can actually who can break that Gordian knot, so to speak, I mean, that person is going to be, that is going to be a great piece of work. But at the moment, that is the very conversation that is being talked about in this literature. This is, I think a lot of this has really just erupted in the last 2 years. last 2 to 3 years, and especially the pandemic obviously heightened heightened a lot of the concerns around this issue. But yeah, no, we do need like new theorization, for example, of how power relations are supposed to work, and how do governments and private corporations fit in the picture here. But yeah, no, sadly, I don't have an answer. I don't know what to make of what is a good constitutional theory for this new configuration.
Not now, in a few years.
Yeah, I wish. Okay.
Other
Yeah.
questions?
Oh,
All right, then I hope you all join me in thanking Anna for
thanks
a
for
super
everything.
interesting talk. And Anna, we super appreciate you taking the time. And I just want to say next week we welcome Ariel Procaccia, the Gordon McKay Professor of Computer Science at Harvard University, whose talk is titled Democracy and the Pursuit of Randomness. So I look forward to that as well. And thank you, Anna. We also look forward to the ongoing work in this project. It's so important.
Thank you. All right. Bye, everyone.